Director Lightbourne, whenever you're ready.
Mr. Cervenka will lead our presentation on this.
Thank you.
Good morning, Mr. Chair, members. Pete Cervenka with the department as well, and I appreciate the way that you framed the issue. First and foremost, we're talking about two federal grants that provide the majority of the flexible funding for child abuse prevention in California. For a number of years, California has been out of compliance with the Federal Child Abuse Prevention and Treatment Act. And this year, the feds have told us unless we come into compliance, those two grants will disappear. One of them is the $3 million CAPTA grant, Child Abuse Prevention and Treatment Act grant, and the other is a $1.8 million grant that goes to the California Office of Emergency Services. We provided a commitment to the feds this year that we would come into compliance this year as a condition of maintaining the current year grant, and that's the basis for the proposal before the committee today. There are two pieces of language that are necessary to bring California into compliance. The first deals with child fatality incidents and reporting. And as outlined in your agenda, and I will point you to starting on the bottom of page 14, we want to make clear that there isn't a child welfare program benefit to understanding what happens in, say, random third-party homicide incidents. Walking home from school and you're hit by a stray bullet intended for somebody else. That's not something that we would report as a child abuse and neglect fatality. We don't think the child welfare system has something to learn. So we have language that clarifies that point. We really want to focus on child abuse and neglect. The last bullet is on page 14 is the most important. Federal guidance changed and said that in addition to all of the things California law currently requires in the reporting of fatal incidents, they also require at the federal level that we provide a description of child protective and other services provided and actions taken by the Child Welfare Services Agency, not otherwise disclosed within other documents that are already being released. So that is a significantly broader disclosure requirement than previously has existed for fatality cases. In addition, on the top of page 15, your first bullet, we are proposing, because of that broader disclosure in fatality cases, it's basically everything that we haven't previously disclosed, to move from the current 10 working day standard that's in law to a 30 calendar day standard. It's a difference of roughly 2 calendar weeks to allow that additional disclosure to occur. So those are the two changes that we're proposing that are necessary to bring California into compliance in terms of fatality reporting. Near fatal incidents is a significantly larger issue. California does not currently have any law on the books regarding the disclosures that must be made in the cases of near fatality incidents. And I don't want to read your agenda to you, but I'll hit some of the high points for this. The first is on page 12, where we have the second bullet, which is a definition of a near fatality case. Federal law says that a near fatal incident is defined as one that results in a child being in a serious or critical condition. Our proposed language says overall condition of critical or serious. We think it's largely the same and more clear that it's the overall condition of the child, not an individual injury, although they may be one and the same in the case of a severe injury. So that first is the proposed definition, and I should have added at the beginning as well that we ran the proposed language past the Federal Administration for Children, Youth, and Families, and they confirmed both for fatality and near fatality that if enacted, that language would in fact achieve California's compliance with CAPTA. Similarly to what I described for fatality reporting, the first bullet on page 13 again takes out third-party homicides that really don't have to do with child abuse and neglect. And then new for fatalities is the significant bullet under that. This is where we begin to describe what must be disclosed in near fatal incidents: a child's age and gender, the date of the abuse or neglect and the date of a physician's determination, where the child was residing, and the cause and circumstances of the near fatality incident itself. Also required to be disclosed is a description of reports received, services provided, and actions taken regarding suspected or substantiated abuse and neglect of the victim and any other children in the house pertinent to the abuse and neglect, and a written narrative including dates of reports, investigations, services rendered, actions taken, and the disposition of those reports. The language also would, for the first time, require all risk and safety assessments be disclosed as well, and provides the same 30 calendar day time frame for this. It does allow the discretion for a county to establish as a matter of its own policy that in lieu of providing written summaries of these reports, that the actual reports could be released themselves with appropriate redactions, of course. And then the rest of the description on page 14 deals largely with what I would describe as privacy concerns. There's a very important distinction to be made between fatalities and near fatalities, in that in the case of a fatality, there is no survivor, obviously, and the privacy rights that attach to that person have disappeared. So the public presumption, both in the fatality reporting section as well as the existing law that governs juvenile court files and their release, has a presumption that their release in a fatality incident is in the public interest, and that information should be disclosed. Obviously, in the case of a near fatality, the child continues to survive. The Child Welfare Agency continues to be involved in the case. The family continues to operate in the community. And as such, we think the privacy rights presumptively should go in favor of the individual unless there is a compelling public interest for the disclosure of certain records. So that's a very important distinction to be made, and that's reflected in the language that's largely summarized on page 14. It's important to note that we agree with the chair's remarks at the beginning about transparency. We think it's important that there be oversight in the child welfare system. We think that the proposed language both achieves compliance and strikes a reasonable balance between the public's interest in overseeing the child welfare system, as well as the rights of the surviving child and their siblings and the rest of the family. We also note that existing law in Section 827 of the Welfare and Institutions Code authorizes what's known as an 827 petition, where an interested party can petition the court to make a finding that the contents of a juvenile case be released to the public, again with appropriate redactions. We think that's an existing protection against any confusion created by summaries that may be created by an agency. We think that's an important double check on the government, that the judiciary has the ability to make that determination. And so I would simply point out that although there is, of course, always interest in achieving actual records, we think it's a well-balanced public policy that the court be the final arbitrator of what actually should be disclosed when the victims are still alive and being served. So I'm happy to answer questions. We know it's a complicated topic and one of great interest and import, and appreciate the committee's consideration.
Thank you, sir. Anything from Finance? Anything from the LEO's office?
Thank you, Mr. Chair. Ginny Bella with the Legislative Analyst's Office. We're continuing to review this language and would just note that the department is facing a difficult challenge here in striking a balance between releasing the appropriate level of information and reporting to satisfy the federal government and, as you pointed out, ensure the safety of children, and balancing that need with the need to ensure privacy and confidentiality of children and families. So we're continuing to work with the department and stakeholders to sort of understand all different perspectives and appreciate the staff recommendation to hold this open to allow a little more time for those discussions.
Thank you. We're going to move to committee member questions. Assembly Member Chu.
Thank you, and let me first thank your department as well as the stakeholders for this issue. I know it has been challenging, it's been controversial, and I have to say that I think, from my recollection last year, virtually every member of the Budget Committee was happy to not have to vote on the proposal last year because I think many of us had a lot of questions and concerns. And as you probably know, many of those concerns, I think, still exist with the current proposal. And if I can just tick through a number of them and love to hear your response, I have to say that I'm not sure of my own perspective at this point, and I just want to get questions back from the department. So the concerns that have been raised are the current proposal still only requires written summaries and not the original case notes, and I certainly support the redacting of privacy information from case notes, but it seems that the case notes really help us understand whether something terrible has happened, and related to that, the language doesn't designate who will prepare that summary, and we know that if you have a local county department that's preparing the summary, they might be writing a child abuse or neglect case summary that could implicate their department, and that, to me, suggests that we would want the original case notes. So that's sort of issue number one. Issue number two that's been raised is how the current language in the proposal excludes cases of abuse and neglect if the perpetrator is a minor who's not in a caretaker role. So the situation that you have an abuse and neglect in a group home by other young people, that is an issue I'd like you to address. Third, I heard how you want to clarify the federal language. I think advocates are suggesting that those qualifiers that are not in federal law somehow water it down, somehow narrow it, and want to get your perspective on that. And then the fourth issue that I want to raise is just around the disclosure time frame. The Public Records Act requires 10 days. You're suggesting 30 days. I think the public generally wants to know things as quickly as possible, particularly if there's a young person in danger. So want to understand your perspective on those issues. Mm-hmm. Okay. And I know you alluded to some of them, but again, if you could just directly, those seem to be the top concerns that still remain with advocates for the very children that we're trying to protect.
Absolutely, and I'll take them in order. Your first question regards the written summary and why that's perhaps preferable to the actual records themselves. As I stated, and you acknowledged, when the child is still alive, I think there's extra care in what should be disclosed. And I think the process of preparing a summary is appropriate. It allows a thoughtful and thorough review of that. I think no government entity has an interest in slanting those summaries or excluding information from those summaries when the judiciary has a very important public check on that process. I think there's a very good check there in the Section 827 process that I described.
But if I could just ask again, if they're original case notes, why do the additional work if we can just look at the notes that could suggest what the issues are? Why do you need to take the extra step and the effort of writing a summary when the raw data is there?
We think it makes good public policy sense for somebody to summarize the events of what's happened. I think it helps provide a comprehensive picture and describe the contextual story for what's happening in the context of the case. Folks would tell you that often it's more difficult to redact and accurately redact than it is to write the summary correctly and maintain the appropriate privacy protections. There are a variety of those things. As I also mentioned, though, we do in the language authorize counties to adopt as their policy the redaction method should they choose to do so.
And I don't have a problem with a summary on top of case notes. That could make sense to contextualize it. I think it's the summary in lieu of the case notes that I'm trying to understand. And certainly, again, I support the redacting of privacy information. But to me, I still wonder if is it that difficult to go through a case file and redact the privacy information, still provide the actual case notes, but and again, if you want an additional summary. Mm-hmm.
Perhaps if I could add, Assemblyman, most frequently, fatalities, near fatalities of children occur for younger children, sadly. So the surviving child, when they are not 2 or 3, but they're 10 or 12 and living in the community, is it in the public interest for the public to know the exact circumstances in which this child was maltreated? That's information that I believe the child should govern. No one has the right to know what kinds of abuse someone suffered earlier in life. That's something you volunteer or you don't. With that which is released, I fully respect the integrity of the journalistic profession and others, but once stories are printed, as we know now in the era of the web and the internet, they never ever go away. If the child has died, then the detail of the maltreatment is non-injurious to an individual and is presumably in the public interest. If the child is alive, the extent of disclosure denies the child the right to control the public's knowledge about them as they grow through life. I think that's the underlying sensitivity we have.
It strikes me that, again, if there are ways to protect the privacy, the name of the child, and as well as any identifying details about the child, if there is actual abuse and neglect, feels like a summary would hide that information, potentially hide that information from the public in a way that could further endanger that child or further endanger other children in that setting. I guess that
I acknowledge there's a balance.
Yeah.
I'm just trying to articulate the importance of finding the balance where a child has not foregone the control of their own personal history. Mm-hmm. That's the struggle that I think we all face. I don't think there's an absolute perfect solution. And I think that everybody who is going to address this issue is approaching it in good faith, but with slightly different lenses and slightly different priorities. The priority of the accountability of the child welfare system, we fully acknowledge the importance of that. Not only does the court play a role, but the department itself. We review all fatality and near fatality reports. We review case files. We go in when necessary and do on-the-ground field investigations if there's something we're not comfortable about. Certainly their advocates will say, well, it was only public disclosure of fatality information that led to reforms. Certainly in the case of fatalities, we do not disagree. Near fatalities, we think, occupy a special place, and we just urge the consideration of the person whose identity may become known with time.
Director Lightbourne, I want to ask you this question. I'm somewhere between what the Assembly Member Chu and you have both offered. I get that sometimes even describing certain circumstances without giving someone's name could actually lead others to identify who that person is. Yep. Mm-hmm. It's sad that we just live in that kind of circumstance now. Let me ask you this. Is there an intermediary step where the person who provides the summation is not someone from the department, but a neutral who would provide the summation so that it would rest any concern that there somehow might not be the full story?
I would certainly say that I think we're open to finding that safe place where there is not any suspicion of collusion or obscuring facts.
Similar to like when there's an audit, right? When
Yep.
there is a serious incident, there might be an audit from an agency that might come in and look. Would the review of the case file be limited to the incidents that led up to the child's injury, or is it a summary of everything in the case file? And I'm asking that out of sensitivity, knowing that there could be information in the case file that dates back years,
Right.
and that may not be directly germane to the particular injury. And so I'm erring on the side of protecting the child's identity. And so I'm asking if the summation narrows in on case files that are specific to the incidents as opposed to publishing what might be a profile of the entire child's life.
The answer to your question is yes.
Yes.
It's specific to
It's
the
specific.
incident.
It's narrow.
It's not the entire family's history of
Got
child
it.
welfare involvement.
Got it.
Again, in a near-fatal case, the child remains alive, the family is in the community.
Understood. Assemblymember Chu.
My apologies. I have a press conference in another part of the building right at this moment, right when I want to get these answers. So I'm going to actually hand my questions over to Mr. Thurman. I hope you can go through those answers. My staff are here. I'll be back probably in about 15 minutes.
And let me announce that there is a meeting today at 2:30 to have further discussion about these issues, and if the Assembly member is able to have someone from his staff there to make sure those questions get answered, could we get that information to Assembly Member Chu's office so he knows when and where, so that we can make sure all of his questions are fully answered?
Yeah.
Thank you. Other committee member questions?
I would love if you could, just on the record, answer the questions.
We'd be happy to go through the other three
great.
that you asked. Absolutely. You asked a question about other minors in a group home. I think it's maybe perhaps instructive to read a very short paragraph for you out of the language. It says, for purposes of this section, abuse and neglect shall not include near fatalities caused by the following persons, and this part's important, unless neglect by a parent, guardian, or foster care provider contributed to the circumstances of the near fatality. And then the language clarifies an alleged perpetrator unknown to the child or family prior to the abuse, or a minor, unless acting in the role of a caretaker, who is alleged to have caused the near fatality. So there are two things that are important here in the example that he used for the question. The first is that in a group home, you have a foster care provider, and incidents between residents in that facility presumably happen in the absence of appropriate supervision and care. So those would, in fact, be disclosed under the proposed language. And the other is his question about acting in the role of a caretaker. If you are acting in a role of a caretaker when the injury occurs as a minor, that will be disclosed as well. So we think the language is clear on both of those points. And I think that also answered his third question about child perpetrators. The last question he asked was around the time frame. Yes, the Public Records Act provides 10 working days for a response of public records. There are a litany of exceptions to the Public Records Act, including ongoing investigations, information that would jeopardize ongoing investigations, privacy protections for persons still alive, etc. But really, in the case of the near fatality, because of the need to protect privacy and do a thorough job of it, we believe that it's appropriate that 30 calendar days be the standard used for that work. And for fatalities, as I indicated, because we are basically amending the law to say everything not already disclosed, there's a significant additional amount of information that will now be required in the cases of fatalities to be disclosed, and that additional workload, again, we believe merits an additional what amounts to roughly 2 calendar weeks, the difference between working days and calendar days.
Interestingly enough, this subcommittee is meeting again this afternoon at a time that overlaps with the meeting that's taking place to further hear concerns and questions about this particular language. But having spoken with a number of the members of this committee, we are trying to arrange to have staff present at that meeting to continue the conversation to make sure that all the members' questions and concerns are addressed. So more to follow. Let's hear from the public on this issue.
Please.
Is there any public comment?
Thank you, Mr. Chair and members. Kathy Sunderling with the County Welfare Directors Association on behalf of the administrators of the system who advocate every day for the protection of these children. So we appreciate your thoughtfulness in recognizing that that really is paramount in what we're talking about here. Really, we do support the proposed language because we think it strikes that balance between making sure that the public receives the information that it needs to know to understand what has happened in a case, see patterns that may have happened over time in cases like this, but also ensure that the children are protected, that their their families that are innocent are protected as they try to recover from the emotional and physical trauma that they've experienced in these situations. Thinking about what happens locally for our directors and for their staff, the death or serious injury of a child on our watch is the most serious thing that can happen. We take it very seriously and take it to heart when it does happen. There is a substantial amount of internal scrutiny that happens to ask these questions. What happened here? Could we have done something different that would have helped this not happen, that would have prevented this? And extensive information that's provided internally, that information can be shared appropriately, we think, with the public as well. There is absolutely a right and a role for the public to play here. The question is, in the case when a child is still alive, how do you ensure that you do that in a way that, just as you hit the nail on the head in your comments a few minutes ago, once it's out there, it's always out there. And not every city is as large as Los Angeles, where one child who has one thing happen to them that's bad, even releasing the original document, somebody may not be able to pinpoint who that is. In many, many other counties of even medium and large size, the communities are small enough that when they see that level of information in the original documents, you know who that kid is. You know that that's the kid. And they can be bullied, and those things can be put out there, and it can enable them to just not recover from that trauma. We need to help them recover, so we need to balance that public right to know and the protection. We think the written summary will enable us to do that. Zero in what happened in this situation, what is the relevant information, and provide the context around that whole investigation of what we find, why it happened, and things that the child welfare system could have done differently in that case too. We think that's the appropriate way to balance the public's right to know and the privacy rights of that child, and specifically of the innocent siblings, the innocent child, and innocent family members who had nothing to do with that incident. And we do want to point out, it's been noted, but I think it's important to come back to, the judge can't have the final say. If the summary is not sufficient in a case and someone is able to make that case under the Welfare and Institutions Code, Section 827, the rest of the documents can be released. On those case-by-case situations where a judicial determination is made, that in those cases the public's right to know wins out. But we think that it makes much more sense to start with the necessary information, truthfully and faithfully reported, which is what we would always do. We're not going to, we have integrity, as you know. We're going to provide that information and provide that summary. And in those cases where people can make a credible argument that there needs to be more released, there is a mechanism to do that. We appreciate your indulgence and your consideration.
Thank you.
Thanks.
Good morning, Mr. Chair. Tia Orr on behalf of the Service Employees International Union. We also stand on behalf of our thousands of social workers across the state in support of this proposal. We also believe that it strikes a very fair balance between the need to be transparent, but also the need to protect abused and neglected children who, as you've heard here today, are still living. One thing I do want to say on behalf of our social workers, and I'm sure, Mr. Thurman, you know this very well, they stand committed to protecting abused and neglected children. As we speak today, we have thousands of social workers on the ground that the state trusts to protect abused and neglected children. We are doing investigations as we speak. We're pulling children out of their homes as we speak. We're creating plans for children to reunify as we speak, because you trust that our social workers are doing the job of the state and are fully going in with all integrity to do the job on your behalf. I would say that when a child is near death or dies, it is, as Ms. Senderling said, the most crucial and important issue that can happen in child welfare. And to assume in any way that our social workers would change their commitment in writing a summary when something so crucial happens is difficult to swallow, to be honest. I would say that our social workers, all of them, work with cases that are stacked up to the ceiling for not that much money because they are committed to this work and they love this work. We are cautious about putting records and information out there that can lead to the identification of a youth that is still living. We believe that in our child welfare service profession and in our specialty and our ability to try to get this child on the right track, that can back the child up and hurt the child more. We've worked with the administration very hard to try to figure out this balance, figure out a way to be transparent. We believe this strikes that balance, and we hope that you take this into account and approve this proposal. Thank you.
Thank you.
Chairman Thurman and members of the committee, my name is Bill Grimm. I'm with the National Center for Youth Law, where I'm a senior attorney there. I want to talk to this from the perspective of one of the actual drafters of SB 39, the Child Fatality Disclosure Bill, and begin with, I think, the critical comment here, which is, since 2007, actually I think the bill became effective January 1st, 2008, as far as I know, there has been no reported harm from the disclosure of the actual records in the CPS file. That's more than 8 years of experience. I have spent a lot of time actually reviewing child fatality files for various members of the press and the television media. And I don't know of any situation where disclosure of that direct information from the case files has harmed a single child. And I can tell you, in many of those child fatality cases that I looked at, there were siblings, there were other children that were survivors, and their privacy interests and their identifying information was not disclosed in any of the articles that at least I've seen about those children. So to a certain extent, this argument about identifying information and the harm to children is a red herring, I think, in all of this. I want to make two other comments, one of which is I'm very glad to hear that we're going to be sitting down this afternoon at 2:30 and trying to work through some of these things, because I think it's possible to come to a compromise on this. But I want to respond to the issue about the 10 days. Okay, what the proponents of the legislation fail to point out is it's 10 days from the conclusion of the investigation, which again, in my experience, when I get these records from the press and the media, is actually far down the line. It's not 10 days from the initial report of suspected abuse. It's often 30, 60, or more days out from the time at which the reported abuse was actually given to the agency and the investigation was begun. So we believe that the 10-day provision should be retained. And then finally, I differ over the exclusion of the minors that the proponents just talked about, and that is whenever you introduce qualifiers into this decision-making, when you ever give somebody the discretion, unfortunately, I think that discretion is going to be exercised on the side of a lack of transparency. That's just my experience in working with these cases, trying to get the information from the agencies over the last 7 or 8 years since SB 39 was introduced. I have a number of other points, but I'll take those up this afternoon in the 2:30 meeting. Thank you.